So, International Tribunal clarified that the Charter is not an arbitrary exercise of powers on the part of the victorious nations, but in the view of the Tribunal, it is the expression of international law existing at the time of its creation. In relation to the crime against peace, as I mentioned today, the court stated that aggressive war was criminalized by customary international law. Argument that if a war of aggression is illegal in international law, then it necessarily follows that those who plan and wage such a war are also committing crimes. Also, it was point of view concerning the ex post facto principle. The prohibition of retroactive application applies only to the criminal law which aggravates the situation of the accused. Clearly, the atrocities committed during World War II could not be unpunished. Therefore, the tribunal did not aggravate, but rather improve the position of suspects and could reasonably have retroactive effect. The rights of the accused were respected. In this case, there is no need to deny the retroactive application of the law, as it is improves, not aggravate, the situation accused. Next, critical remarks. The trials were victorious justice. Such statement contains a number of different allegations. The judges were prejudiced against the accused. The applicable law was designed to guarantee a conviction. Similar acts were committed by the prosecuting states, but were not prosecuted. For instance, the advocate of defense told that United States practice in sphere of submarine warfare was the same. However, the defense were not permitted to raise the issue of crimes committed by Allies. Indeed, the tribunal was not perfect in terms of modern international criminal law. However, no doubt the Nuremberg Charter and the judgments of the tribunal are of great value for the development of contemporary international criminal law, and more particularly the concept of individual criminal responsibility. Why it is so important? For the first time, non-national or multinational institution was established for the purpose of prosecuting and punishing crimes having an international dimension. The Charter defines offenses for individual criminal responsibility. New offenses were envisaged in the London Agreement and made punishable: crimes against humanity and crimes against peace. The new legal norms and standards of responsibility were created. For example, provisions on obedience to superior orders and the accountability of heads of state. Both the Charter and the judgments of the tribunal have been extremely important for the evolution of the law and the procedure of more contemporary institutions, namely International Tribunal for former Yugoslavia and International Tribunal for Rwanda, as well as the establishment of International Criminal Court. The charter and the judgment of the tribunal formed the starting point for Convention on the Prevention and Punishment of the Crime of Genocide, 1948, Geneva Conventions related violations of international humanitarian law for Geneva Conventions, 1948. Also development of domestic legislation among states prescribing the offenses against international law as set at Nuremberg. If the tribunal was not created, the option of summary execution had to be realized, and it had to be lynching without trial. It was proposition that it was enough to arrest and hang those responsible for determining and applying Nazi policy, the main German offenders, without wasting time on legal procedures. Minor criminals, they suggested, could be tried by specially created tribunals. To hang them without trial would mean to undermine one of the mainstays of democracy. No one can be considered guilty until his crimes have been proved in a fair trial. Rejection of such a fundamental principle would put the Allies on a par with the Nazis, who grossly violated many principles of justice. They conducted fictitious trials and punished without resorting to a trial. One of the tasks of the tribunal was to expose the heinous crimes of the Nazi for all humanity to see. Okay, let's talk now about another criminal tribunal, about International Military Tribunal for the Far East, or Tokyo Tribunal. Unlike the Nuremberg Tribunal, the Tribunal for the Far East was established not by treaty, but on the basis of a special proclamation adopted on 1946 by the Supreme Commander for the Allied forces in the Pacific Theater, General Douglas MacArthur. The purpose of the tribunal for the Far East was to try the major Japanese war criminals. In September 1940, Japan signed the pact with Nazi Germany and Italy, in which they agreed to assist one another. Japan attacked the US naval forces at Pearl Harbor, Hawaii, on December 1941, destroying 80 ships and killing almost 2,500 people. Over the next 7 months, Japan occupied a number of territories in Southeast Asia and the Pacific. Japanese troops committed thousands of grave crimes. The tribunal was made up of 11 judges. The United States was entitled to appoint the chief prosecutors, whilst the other countries were only permitted to appoint associate prosecutors. The defense was undertaken by a number of Japanese and American lawyers. The indictment of the International military tribunal for the Far East charged 28 accused with crimes against peace, war crimes, and crimes against humanity during the period from 1928 to September 1945. The trial lasted nearly 2.5 years, with the majority judgment being pronounced in November 1948. The judgment found all the accused who remained before the tribunal at the time of judgment guilty. Of the 28 accused, it sentenced 7 defendants to death, 1 to 20 years imprisonment, 1 to 7 years imprisonment, and the rest to incarceration for life. Although the tribunal was established with the aim of prosecuting the most senior Japanese officials holding both political as well as a military position, this did not affect Emperor Hirohito. He was not brought to court. Also, the emperor had to be responsible for initiation such a war. The emperor was not accused on the ground that his immunity was necessary for Japan's post-war stability, and he was deliberately non-mentioned by the prosecution nor the defense, with the one exception. Cold War consideration led to the United States to agree in the release of all imprisonments by 1958. One more fact I would like to pay your attention. It is the use of nuclear weapons against Hiroshima and Nagasaki in 1945. On August 1945, the United States dropped an atomic bomb on the Japanese city of Hiroshima. In a press release issued after the atomic bombing of Hiroshima, President of the United States Truman warned Japan to surrender. 3 days later, on 9 August, the United States drops another atomic bomb of Nagasaki. As a result of these two explosions, more than 200,000 people died. At August 10, 1945, Japan officially announced its readiness to accept the terms of surrender. The necessity of the atomic bombing has long been debated whether they were necessary. The position of the Allies was that the atomic bombing were justified as they brought an end to the war, because the atomic bombing shocked the Japanese government and the Japanese government surrendered, and the emperor finally indicated his wish to stop the war. Another argument in favor of the atomic bombs is that they helped avoid the prolonging of blockade and conventional bombing campaign, any of which would have exacted much higher casualties among Japanese civilians. Okay, let's talk now about such mechanism as Control Council Law number 10 trials. The Nuremberg Charter provided for the trials of major war criminals of the European Axis, Germany and Italy, and the International Military Tribunal for the Far East was created for prosecuting of the most senior Japanese officials. In addition, the same crimes committed by lower-ranking defendants were considered according to Control Council Law Number 10. The Allied Control Council in Berlin, composed of the military governors of the 4 occupation zones: the British zone of Germany, the French, the US, and Soviet zones of Germany. This act mechanism was created in 1945 at London Agreement. Law number 10 concerns punishment of persons guilty of war crimes, crimes against peace, and against humanity. It authorizes each occupying authority to set up war crimes tribunals within its own zone of occupation and to try war crime suspects under the substantive regulations of law number 10. The legal authority advanced by the Allies was based on the fact that they carried out the functions of government in Germany. Such reasoning meant that these council proceedings were part of domestic law of Germany, but not German judges, rather occupied judges, victors, judges. The most famous were Nuremberg trials, which were held by the USA. It was so-called Little Nuremberg trial. These were a series of 12 military tribunals for war crimes against members of the leadership of Nazi Germany, lasting from December 1946 to April 1949. 12 major US trials took place in Nuremberg after the International Military Tribunal had concluded its work. This include the trials of Nazi doctors, judges, German industrialists accused of using slave labor and plundering occupied countries. In the other occupation zones, similar trials took place. What happened after the Nuremberg trials? After the Nuremberg trials, there were years of silence from 1945 to 1992. By 1955, Control Council Law number 10, proceedings has ended in Germany. Prior to that, the Far East military tribunals had also ended, and like I said, by 1958, all tribunals for the Far East convicted war criminals were released. In the West, Germany continued to prosecute persons charged with crimes arising out of World War II, as did some other countries, according to the universal jurisdiction. Since World War II, there have been many conflicts for which no international investigative or prosecution bodies were set up. Why? Because of the Cold War. Also, it is necessary to know about such documents as affirmation of the principles of international law recognized by the Charter of the Nuremberg Tribunal, This document was adopted by General Assembly Resolution 1947. Affirmation of the principle of international law recognized by the Charter of the Nuremberg Tribunal. And I want to draw your attention to the role in general of the Commission, International Law Commission, in the post-Nuremberg era. After the Nuremberg proceeding, the International Law Commission played an important role in the development of international criminal law. In 1947, General Assembly requested the International Law Commission to formulate the Nuremberg judgment and charter provisions into a set of principles, and also to prepare a draft code of offenses against the peace and security of mankind. It had to be like international criminal code, like in national legislation, criminal codes. Then Commission works in preparing the draft code of offenses was undertaken in two distinct phases, from 1947 to 1954. And the second period, 1982-1996. But unfortunately, the completion of draft code was never achieved. The International Law Commission in 1951 submitted the draft code to the General Assembly. The Assembly felt that definition of aggression raised problem and decided to postpone the consideration of the code until further work was done on the question of aggression. A definition on aggression was adopted with consensus some 20 years later, only in 1974. And then Commission once again suggested to resume examination of the code, only in 1981. The Commission resumed its work in 1922, started to work, and by 1996 it had adopted a final set of 20 draft articles constituting the Code of Crimes Against the Peace and Security of Mankind. And it included the following categories of crime: aggression, genocide, crimes against humanity, and war crimes, and also such category like crimes against United Nations and associated personnel. But the code did not come in force. On July 1998, the statute of the ICC was adopted. From a legal point of view, of course, the possible adoption of the code would be relevant only for those countries that had not ratified the ICC statute. Okay, that is all for today. What question do you have, or do you have any remarks and thoughts on the topic of lecture? Please. Guys, do you have any question?
I have a question. Why it is so important to create an international tribunal regarding the crime of aggression by the Russian Federation against Ukraine?
Yes, really. This is important because our country now are under the war, under aggression of Russian Federation, and impunity is largely responsible for the mass crimes committed by the military during the war, any war. That is why the inevitability of punishment must become our principle if we want to prevent new atrocities by Russia in Ukraine and protect basic human rights and in general international security system. If we want to ensure that Russia's political leadership is held accountable for the atrocities committed in Ukraine, we need to find them guilty of the crime of aggression. And idea of creating this special tribunal to prosecute Russia for aggression against Ukraine was first voiced by Minister of Foreign Affairs of Ukraine, Dmytro Kuleba, in March 22. And tribunal must be established on the basis of a multilateral treaty between states, or maybe it is another way, an agreement with an international organization, United Nations or EU or Council of Europe. And this special tribunal would be aimed at complementing and not replacing the work of the ICC in Ukraine. So it is important to create this tribunal, and it would be serve as a lesson for future generation.
Thanks.
Okay, thank you very much, guys. Today we considered the development of International Tribunal of Nuremberg and International Tribunal in Tokyo. We considered the temporal, personal, territorial, and subject matter jurisdiction of this tribunal, as well as questions of the implementation of justice for war criminals after the end of the Nuremberg trials. Goodbye, have a nice day, see you next lecture.
Thank you so much, goodbye.